Good morning, everyone.
Hello.
We would like to welcome you on this webinar, which is designed on the internationalization capacity of the companies. This in practice means how you will measure your readiness to go abroad. Together with my colleague Kamen Chanev and my colleague from our Prague office of King's Tower, Zdene Kuchera, we will lead you through the main topics regarding this internationalization. Just few words for us. Kamen Chanev actually is an associate in King's Tower Sofia office, who is focusing on data protection, merger and acquisition, and also some specifics of IT law. And Zdene Kuchera is our head of TMT and also dispute resolution practice in our Prague office. And he's also lecturer in the University Charles in Prague. And I hope that you will enjoy our presentation and will be very much open to answer your question. Feel free to send this question through our Q&A. So I give the floor now to Kamen.
Thank you, Tony, for the kind introduction. Well, the topic of internationalization is a rather broad one and can be discussed quite extensively in business, legal, socioeconomic, and cultural terms. And as far as the automotive industry is concerned, internationalization is actually not a novel concept. In fact, the car industry itself is very old and prolific and has a very long history, which is why most of the major car manufacturers from developed countries have long been acquainted with the notion of internationalization. But this is not entirely the case with emerging markets and developing countries, which is why we think that this is a very interesting topic in this case. When we look back 10 years in the past, the financial crisis has made a serious blow to the automotive industry. And to give you a quick example, General Motors, Chrysler, and Ford, which were three of the top automotive manufacturers in the United States, were almost driven to the brink of insolvency. And the federal government had to bail General Motors and Chrysler out from bankruptcy. In contrast, Ford managed to handle this situation on its own by raising capital from the capital markets and by taking some very difficult decisions, such as parting with Volvo, Jaguar, and Land Rover. As a result from the financial crisis, we have observed a notable paradigm shift in the sense that the big markets that once accounted for most of the production and sales are now saturated and diminishing. And it appears that manufacturers have now moved to emerging economies to reap the high growth rate there. For example, we have seen that there is a growing number of production and assembly lines in countries like Brazil, China, India, Mexico, but especially with respect to Europe, we have seen that Central and Eastern Europe are now very attractive emerging markets for internationalization. This is primarily due to the fact that they have certain geographical advantages, meaning that they are very close to already large existing markets, such as Germany, France, and Italy, which are among the greatest manufacturers in the automotive industry. So our first part of the presentation today is closely related to some of the issues that most of the international companies face. And speaking strictly in legal terms, there is a great number of issues that need to be considered. This means that there are issues from such as corporate issues, such as how the company is going to structure its business, to financial, tax, and property issues, as well as employment-related issues. So, since it is impossible to capture all potential pitfalls that the company might face, we have decided to limit the scope of our first part of the presentation, specifically to mobility of personnel, employee benefits and the retention of key staff and talents, and finally to compliance. But first, before I go on with the presentation, I would just like to make a very quick preliminary remark, which I think is always important to stress and should never be underestimated. All of those issues depend to a large extent on the jurisdiction where the company has decided to establish its business operations, meaning since this is law, and it will have to be the approach of the company will have to be tailored to that jurisdiction. Okay, so the first two topics that we have chosen for today's presentation are primarily employment related. This is mostly due to the fact that in the automotive sector, there are many different industries associated with the production, wholesale, retail, and maintenance of motor vehicles. And this also includes IT companies as well. They are very tightly related to the sector. For instance, in the EU, about 6.1% or 13 million people from the employed population work in the automotive industry, which is why we think that these are very important topics. So, as far as mobility of personnel is concerned, it is needless to say that when a company has decided to expand its business operations in another country, it usually has to carry out a recruitment campaign. In such cases, it would usually aim to hire members of the local workforce in order to avoid some of the more stringent legal requirements. But in some cases, the company would have to use some of its already existing employees. They usually include top managers, other members of the management bodies, or highly skilled workers. So for this reason, the employees at issue may need to be moved from one country to another. So when we talk about mobility of personnel, we usually refer to such cases in particular, where the employee, either an existing or a potential one, may need to relocate from one country to another. So a lot of the developed and most of the developing countries, they normally have already extensive employment legislations in place that govern labor mobility and migration. So it should be noted that in the EU in particular, there is no specific competence for the EU to legislate in employment matters, but it has shared competence with respect to immigration matters. So in these cases, it is very important to note that the EU is a crucial destination in such cases because it already has a very wide legislative framework. So mobility of personnel can generally be looked at from two perspectives. The first one is when companies recruit highly skilled workers that need to be relocated from abroad. And the second one is in the circumstances of intra-group transfers, that is, say, where an existing employee needs to be relocated from one country where the company operates to another. In such cases, employees may be relocated only for a short period of time, or such as 6, 12, or 18 months, or on a more permanent basis. In regional blocks such as the EU, relocation of individuals from one EU member state to another is relatively easy, but this is not entirely the case when the employee is a so-called third country national. So in such cases, different schemes may apply depending on the legal requirements in each specific country. But in the EU in particular, we have two very important schemes. The first one is the EU Blue Card, and the second one is the so-called posting of workers under the Posted Workers Directive. With respect to the EU Blue Card, this is a scheme which is meant to attract highly qualified workers from outside the EU to come and work in the EU member states. It grants the workers the right to live and work in the EU country they have chosen. Of course, this is subject to a specific application procedure, and I will give you a little more details about it in a few minutes. But first, you should note that there are certain criteria that need to be fulfilled in advance. In particular, the worker needs to have higher professional qualifications, such as a university degree. In addition, the worker must already have an employment contract or a binding job offer with a high salary compared to the average in the EU country where the job is. This means, with respect to the last criterion, most of the EU countries have introduced the minimum threshold of 1.5 times a higher salary than the salary that is usually given in such positions. Now, needless to say, obtaining the blue card depends on a special application procedure, and this can usually be initiated by both the employer or the employee, but usually it is the employer that takes the necessary first steps. Now, as I already said, most of the jurisdictions have a specific nuances in their legal frameworks, and they all need to be taken into account. But in some cases, there are notions that are very similar. For instance, in some countries such as Latvia, the Czech Republic, Slovakia, and Bulgaria, the worker may also need to obtain a visa in addition to the blue card. But other requirements can vary greatly. And for instance, these relate to the duration of validity of the blue card and the costs for relocation of the employee. Regarding the duration of validity, in some countries, the duration of the blue card may be for 1 year, and in cases of renewal, such as in Bulgaria, after the blue card is renewed from the initial period that it was granted, it can be renewed for an indefinite duration period. In other countries, this is not entirely the case. In other countries, there is a fixed duration period, such as 3 years or 5 years, or a duration period fixed to the period of the employment contract. Now, the blue card in itself has faced certain criticism abroad and in the EU. For instance, we have seen that countries in Africa have stated that it has resulted in a brain drain from their countries. But in the EU, the scholars and practitioners have actually said that the blue card is just another visa. But we have seen some statistics from Eurostat where we have seen that Germany in particular is the greatest issuer of blue cards, with over 14,000 blue cards issued in 2015. In contrast, some other countries, such as Italy, the Netherlands, and Spain, this is not the case, and they issue no more than 20 to 60 blue cards per year. And this scheme in particular is very popular in emerging markets, such as the Czech Republic, Poland, and Romania, and which is important for the IT and the automotive industry as well. Now, another option for relocating employees is the so-called posting of workers. In the EU in particular, I already said that there is an EU-wide legal instrument that has provided minimum harmonization of the legal requirements. And under this directive, a posted worker is an employee who is sent by his employer to carry out a service in another EU member state on a temporary basis in the context of a services contract, an intergroup transfer, or carrying out through a temporary agency. Now, this directive was recently revised. In fact, I think it was in the middle of 2018 that the final text was adopted. But it is important to say that even the previous reduction of the directive was very important because it guaranteed certain rights to workers. In particular, under the previous directive, workers were guaranteed minimum rates of pay, maximum work periods, and minimum rest periods, minimum paid annual leave, protection for pregnant women, and many others. Now, the new, the revised directive has built on this, and it has made sure that workers are now also guaranteed not only minimum rates of pay, because apparently this resulted in discrimination against the workers. They were relocated from one EU member state to another, and then they were paid the minimum salary of the host country, which is apparently not very nice for the workers. So the new directive has imposed new conditions requiring that the posted worker now can enjoy all the elements of the remuneration, including different allowances if such rules exist in the host member state. In addition, under the previous regime, collective agreements did not apply to the posted workers. That is to say, those collective agreements that are not universally applicable. But under the revised directive, now all collective agreements apply to the posted workers. In addition, in terms of long-term postings, the posted workers are now entitled to all terms and conditions of employment of the host state. So you can see that this is very attractive to potential workers that would like to relocate, which would eventually help in the internationalization campaign of the company. Now, in our experience, we have seen that clients have frequently faced exactly these situations, how they can relocate either a third country national to a new member state or some of their already existing employees from one member state to another. We have recently advised the Tata Industries they wanted to relocate some of their existing employees from India to Bulgaria. And it appeared that both the EU blue card and the posting of workers were viable options. But in the end, we advised on a hybrid solution. So in such cases, there are many different possibilities, and employers have different flexible solutions that they can employ. So it is one thing to relocate workers, but it is a totally different thing to retain them. And this is by all means no easy feat. Now, I'm certain that we are all familiar with the various benefits that employers can afford their employees, such as competitive remuneration, parental leave longer than the minimum period allowed by law, additional healthcare coverage, meal vouchers, discounts at certain stores, etc., etc. But to what extent those benefits work is a whole different issue. In our presentation today, we have decided to discuss two other strategies that have gained popularity and traction in the recent years. The first one concerns share incentives. And share incentives are usually those scenarios in which the employee can buy a share in the company for which he or she works directly or in the parent company. This is usually granted in the form of a share option. That is to say that the employee has the right to buy the share at some time in the future at the price fixed on the day the option is granted. Assuming growth in the share price, the employee has the opportunity to buy shares at a price less than the market value. We have seen that this specific strategy is quite popular in Ireland in recent years, but it is expected that it will also gain a lot of popularity in emerging markets as well. But of course, as with everything, there are various legal risks that need to be taken into account in such cases. And again, they largely depend on the jurisdiction where the worker is employed. So, for instance, there are some tax and social security repercussions that need to be taken into account. Some countries require as a basic condition that the employee remains employed by the company to receive the share incentives. In other countries, this is not the case. In other countries, the share incentive or the dividends that are paid from it are considered just as a normal monetary remuneration. In addition, companies that decide to offer share incentives have to take into account securities legislation. This is highly regulated and depends to a large extent on each of the country's jurisdictions. But essentially, it means that companies may have to file a prospectus in some cases. For instance, in the Czech Republic and Hungary, if the participants to the share incentive scheme are over 150, in such cases, it may be necessary to file a prospectus. In other countries, this is not the case. Also, there are employment legislation issues that may need to be considered. We know that in Romania, the employer may have to carry out consultations with trade unions, works councils, and other employee representatives. And finally, in some cases, there may be some foreign exchange laws that may play a crucial role. For instance, in Romania and Bulgaria, there might be a requirement to notify the national bank if payments have been made to non-residents. Now, in our experience, Clients are usually interested in those four aspects in particular when they seek to implement share incentive schemes. One of our clients, it was Cineworld, I think, they were seeking advice on such matters, particularly in Bulgaria, the Czech Republic, Hungary, and Romania. And we help them navigate those issues to make use of certain exemptions under applicable legislation. As mentioned earlier, the other strategy concerns retention bonuses. Now, to be honest, retention bonuses are not that different from the classic types of bonuses that can be afforded to employees. But we wanted to briefly touch upon this issue because it is very special in terms of the cases when it can be used. Usually retention bonuses come in handy when employers engage in business transfers, for instance, mergers, acquisitions, partial transfer of business operations, or general change in the ownership over the company. Now, an unfortunate result of those cases is that employees can frequently decide that they do not like the new circumstances and they may need to look for career opportunities elsewhere. So retention bonuses come to the aid to employers, and it is a useful tool because it is very flexible. At least in Bulgaria, there is no specific legal framework that governs retention bonuses in particular. So the employer can work around based on the general contractual legislation. So, for instance, the employer can agree with the employee to pay the bonus on installments, for instance, at the 12th, the 24th, or the 36th month, which means that in that way, the employer is obviously able to secure a more long-term commitment on part of the employee. Now, in addition, the company may bind the retention bonus to other factors such as performance results and good conduct by the employee. Now, one common trait that both mobility of personnel and employee benefits have in common is that they need to comply to the fullest extent to the laws of the relevant jurisdiction. And this is where the issue of compliance comes in. We would like to state from the beginning that there is no uniform definition of compliance, but it essentially means that a company is compliant when it abides by all legal requirements and ethical standards. So it is possible to look at compliance from two perspectives. The first one is regulatory. That means that the company has to comply with all the general laws of the host country, with all regulations and judicial practice, which generally includes tax and labor legislation, health and safety, environmental laws, antitrust laws, and from very recently also general data protection regulation. And the other thing is that regulatory compliance also concerns sector and industry-specific legislation, which includes permits that may need to be obtained, licenses, authorizations, or any other approval regimes. On the other hand, a company is compliant if it behaves ethically. So if it has such conduct that sends a specific message about it and its integrity and its ethical system. So, the compliance of the company is usually implemented with the compliance management system. So why bother doing this at all? Well, smaller companies that based in just one city or in one country and are not that big, and they usually entrust one department or several departments in their organization or one person, usually tasked with financial, human relations, or legal responsibilities to also carry out compliance. But when a company decides to move abroad or to establish its operations in other countries as well, it is highly likely that it will be subject to much greater scrutiny. So in such cases, there are many different aspects that need to be taken into account. So Some of the risks are purely operational. As I said, sector-specific legislation may require that a permit is obtained. This, for instance, concerns when the company has to build new facilities and it needs to acquire a building permit. Otherwise, it cannot perform its operations. Other issues concern the reputation of the company. Failure to comply with local laws and ethical standards usually generates a lot of negative reputation for the company. And a company that does not meet its contractual obligations with its business partners or does not treat its employees well enough may quickly amass such negative reputation as a business partner and employer, which also sends a critical signal to the host country. Ultimately, states punish non-compliant companies by imposing various administrative or criminal sanctions. Depending on the severity of the violation, administrative fines can vary from as little as a couple hundred to tens of thousands of euros. Such administrative sanctions can be found, for instance, in the environmental legislation. Another good reason to comply with local and international regulations also concerns the cases in which the company may eventually decide to go public. An effective compliance program promotes greater accountability and transparency, but it also sends a message of security to potential investors. So based on what I have said so far, it is obvious that it is very important for companies to have from the very outset of their expansion campaign a risk-based culture incorporated in a structured compliance management system. I will not go too much into details here because, to be honest, there are specific certification standards of International Organization for Standardization. These are namely ISO 19600, which concerns general compliance, and the other is ISO 37001, which concerns anti-bribery compliance systems. But I will give you just a few examples of the steps that you will have to go through when you start to implement the compliance management system. Well, in the first place, you would need to put your organization into context. This will help you to identify external and internal issues. This will help you to set the business activity of the organization into a specific framework that will help you to identify potential regulatory, social, and cultural pitfalls. The second step is that you have to decide what the scope of the management system would be. This will help you to determine whether it would apply for the entire organization or you will create a different structure that is more tailored to the jurisdiction in which the company operates. The third step, it may also be one of the first steps as well, is defining the leadership. In such cases, usually a chief compliance officer heads the compliance department, but it can also be a compliance committee. And it is very important that they are determined to show and committed to the compliance management system by themselves. For instance, the chief compliance officer should preferably be an individual with a legal background, and they should have sufficient experience in the same industry field in order to be able to navigate all the risks. Then you have to be able to identify the risks, and those can be external and external risks, such as purely from your employees or from your business partners, but also regulatory risks, and you have to be able to assess what the business environment is. The next step is assessing the risk, whether it is legal, whether it is purely social, in terms of image, whether it is strategic, operational, financial, or reputational risk. And then it might be very useful to create a register where you would be able to evaluate the risk. Then in this register, you will be able to assign risk levels, you'll be able to prioritize how you react and respond to the risks, which is also the next step, risk management. And it concerns how you essentially respond to the risks, what internal controls you have in place, whether it's a code of conduct applying for, in general, for the entire company, compliance policy for each of the branches or the places where you operate, But also, in some cases, you may want to implement other systems, such as an insurance. We have seen recently that some clients have started to seek insurances for cybersecurity risks. In Bulgaria, there are only a couple of insurance companies that offer such insurance, but in a broader context, this will gain popularity in the future. Of course, it is important to monitor the risks, which includes periodic audits, and having a compliance management in place is one thing, but making sure that it works and adapting it to business changes is another. And finally, you have to be able to communicate to all your employees and partners how what your organizational culture is and how it manages all those risks. Okay, last but not least, I would just like to say a few words about the conduct part of the compliance management system, which usually concerns anti-bribery and anti-corruption. Now, this is in itself a very large topic, and it is usually worthy of a week-long training session. So I will just briefly mention some of the key aspects. In some countries, such as Bulgaria, there is no clear-cut definition of corruption. The term essentially means requesting, offering, giving, or accepting directly or indirectly a bribe or any other undue advantage or prospect which distorts the proper performance of any duty or behavior required of the recipient of the bribe. But it is important to note that corruption does not necessarily mean only bribe, because there are many other corruption-related offenses, for instance, embezzlement, extortion, power brokerage, abuse of office, and many others. So generally, companies react to such conduct in two ways. The first one is strict corporate criminal liability, which we have seen in the Czech Republic, Slovakia, and Romania, which usually means that the company can be liable in itself for criminal conduct carried out by its employees or top officials. And usually this results in the so-called death penalty of the company or its dissolution, but it also attracts heavy fines. The other way to tackle this for companies such as Bulgaria is imposing quasi-corporate criminal liability, which concerns primarily administrative sanctions. And in Bulgaria, this can be a very high sanction, up to 10 million Bulgarian level, or approximately 5 million euro. With that being said, you also have to be aware of the extraterritorial laws. These, for instance, are the Foreign Corrupt Practices Act in the United States, the Bribery Act in the UK, and the Corruption of Foreign Public Officials Act in Canada. What we mean here is that some laws apply out of the territory of the country where they have been adopted. For instance, in the Bribery Act of the UK applies in cases where a company has, for instance, a branch in the UK, but a bribery has or corruption-related offenses has been carried out in another country. So the act would apply if it can be, of course, detected. So with that being said, the compliance management system can either have in it integrated anti-bribery and anti-corruption management system as well, or the companies can create a bespoke compliance management system that specifically concerns anti-bribery and anti-corruption. And this bespoke compliance management system would be more detailed, and it would concern due diligence checks of partners and many other aspects that need to be taken into account, such as including specific clauses in contracts with employees, with suppliers. So it is a whole different issue that needs to be considered. But to wrap it up, I would just like to give you a quick example. One of our clients is a very large multinational company that has a very detailed compliance management system and anti-bribery and anti-corruption system. And even in this case, the thing is that people are fallible and they are prone to making mistakes. So both the FCPA and the UK Bribery Act have been put into effect, where this company was unfortunately engaged in corruption-related offenses. So even if you are compliant, this does not mean that you will avoid everything, but it's something that you need to take into account. With this, I would like to just say that we have some examples here in the presentation. This will be distributed later. And I would like to give the floor to my colleague Zdenek, who will now talk more about the IT and the intellectual property and artificial intelligence related aspects of the industry. Thank you so much for your attention.
Good morning from Prague. Hello, everyone. Thank you very much for joining this webinar, and thank you very much for the invitation. My name is Zdeněk. I'm based in Prague, and in Kinstala, I co-head the TMT sector in all countries, in all 10 jurisdictions, all 10 countries we operate. During this webinar, contrary to what my colleague Carmen was in detail talking about, it means the legal consequences, detailed legal implications, I would rather like to guide you through what we see is the future, is the development in information technology law that is pretty much driven by the development of technology itself. In Kinstala, we work very close with New York, with London offices of our partners, and we try to follow the development in the technology. And I will also provide you with a few examples of the mandates we have had in automotive industry so far, with a specific focus on 4 topics. First one being the artificial intelligence and autonomous driving. Second will be smart contracting and blockchain. Third would be new forms of electronic contracting with a specific focus on chatbots. And the last one will be quite a specific example how you can use the data that's you have in the car, the data of the driving, the data of the driver. We will, of course, since we are lawyers, go into the details of legal implications. Nevertheless, mostly we will be talking about the new technologies, and of course, we will be very happy to follow up in any subsequent question, in particular by email, which you will find at the end of the presentation. To start with, let's have a look what is ahead of us. Ahead of us with a new legislation on the level of the European Union. And the new legislation, as I said, is pretty much driven by new technologies. So we are expecting in 2019, maybe in 2020, a new European regulation that is called e-privacy. E-privacy is the regulation that is complementing a GDPR, so it pretty much relates to personal data. In your business, in automotive industry, it will in particular affect the direct marketing in retail sector. So anything that relates to cookies, that relates to sending of marketing messages, should be newly viewed in light of e-privacy regulation. So not only GDPR, also e-privacy will come into play. Second piece of legislation we expect, but not in 2019 or 2020, but much further, will be a regulation relating to artificial intelligence. I will guide you through a few pieces of recommendations and few pieces of information that are currently prepared by the European Union. However, currently we have no specific draft of legislation relating to AI. Nevertheless, we should monitor it closely, since in particular automotive industry is quite heavily affected. Third piece of legislation relates to ISP liability. It means the liability of content providers. That does not too much relate to automotive industry. Nevertheless, ISP liability will be increased by the EU regulations and directives in the future, in particular the liability for the content on the website. And the last piece of legislation we expect quite soon is a copyright reform. Copyright reform should come into effectiveness the next year, 2019, and it will enable on the level of European Union to first copyright reform, second trademark reform. So trademark reform will enable to register new forms of trademarks. Three-dimension trademarks is the best example, and copyright reform basically relates relates to enforcement mostly, and there are also two articles, Article 11 and Article 13, that relates to the liability of the ISP providers as well. The new technologies, they pretty much are the driver for the new legislation. So what we see is the future is artificial intelligence, is 5G. 5G means the extension of the traffic for the networks, mobile networks in particular. That is very important also for automotive industry, because extension of the traffic basically means a wider opportunity to connect Internet of Things to the Internet. It will be cheaper, it will be quicker, and therefore there will be much broader use of Internet of Things in the upcoming years. In our countries, in our jurisdictions, it is expected that 5G auctions, that the 5G markets by way of auctions will be opened 2019, for example, in Czech Republic, in 2020 in more countries, including Slovakia, Romania, and so on. New technologies include also smart contracts and cryptocurrencies. We will touch this a little bit in the presentations. And since we are talking about new technologies, we should not omit the cybersecurity. We have a new directive on the level of European Union that has been introduced into the national laws. Most of the countries have already implemented so-called NIS directive. Nevertheless, there are still some, for example, Romania, that are pending. Therefore, cybersecurity is now a very big topic. Let's start with a specific questions relating to technology. Artificial intelligence. Artificial intelligence, you might remember from the past, from the Jeopardy, the competition in the United States of America, where artificial intelligence based on Watson IBM technology basically won the competition. That was the first public presentation of artificial intelligence. Nevertheless, we see artificial intelligence also on the street. On the screen, you can see small delivery automated equipment that is used for delivery of foods in the United States of America. Another example in logistics are the drones. And when we are talking about the artificial intelligence, they have certain part of artificial intelligence. The drones I'm presenting are protecting the Israeli border, and they are based on certain level of autonomous decision making. Basically, these drones, after they fulfill their mission, it means the review of the border, they come back, they do the data analytics, they charge themselves, and when they are ready again, they autonomously fly again for their mission. So autonomous drones. Artificial intelligence in security, you can see a robotics police that is now operating in Dubai. Don't be scared that these automated guys are not wearing the guns. They are more for protection of the traffic and for information to the tourists and citizens. Nevertheless, they have certain level of automatic decision, which is very important also from legal perspective, as we will discuss in a while. Artificial intelligence is also used in healthcare. The example can be the automated operations, for example, in a cardiovascular industry. A very important thing is that the artificial intelligence, the automated systems, can now see, can now hear, can now feel, and can smell, and therefore it creates a huge amount of data that they can analyze, and on basis of the data analytics, they behave how they decide themselves. And that is very important for the automotive industry. You have probably seen and heard about the discussions relating to autonomous driving used by Uber or by Tesla. Nevertheless, it's very important in automotive industry to distinguish between the certain levels of automation. The first one, the level 1, is are some small steering or acceleration tasks performed by the car without human intervention, but everything else is fully under human control. We have second level of automation. It's like advanced cruise control or original autopilot system on some Tesla vehicles. The car can automatically take safety actions, but the driver needs to stay alert at the wheel. This is what you mostly know from the car that are currently understood as automated, but in fact they are only on level 2 at this stage. There are 3 more levels, and these three levels are understood as the real automation. The level 3 still requires a human driver, but the human is able to put some safety critical functions to the vehicle under certain traffic or environmental conditions. This poses some potential dangers as humans pass the major task of driving to or from the car itself, which is why some car companies, for example the Ford, are interested in jumping directly to level 4. In level 4, the car can drive itself almost all the time without any human input, but might be programmed not to drive in unmet areas or during certain weather or traffic conditions. It means that this already is the car where you can basically sleep in, and not all the time, but most of the time. And then you have the 5th level of automation, which basically means that the car drives itself without any human intervention. We see a huge investment in autonomous driving. Ford announced in February this year that it is going to be investing $1 billion in artificial intelligence technology for their car. Renault Nissan announced that in 2020 there will be autonomous cars in urban conditions, and in 2025 they will have a truly driverless cars. Hyundai announced that on highway you can use their automated cars in 2020, and urban driving would be possible in 2030. And BMW announced that fully driving in BMWs will be possible by 2021. These investments are enormous. Nevertheless, there are certain legal constraints as well. You might remember that there was a big car accident caused by Tesla or by Uber, and this is the huge challenge for law. Why for law? Because we have an entirely new system. We have this level 4, level 3, level 5 autonomous driving that is based on the decision of the car itself. And when you have, and this is what we call self-learning, and when we have incorrect process of self-learning, then we might have a problem. You might remember these examples. There was a Thai chatbot developed in 16-17, and this chatbot was learning as it was used. And during 1 week, the users learned the chatbot to deny the Holocaust. Therefore, the chatbot was cancelled. So the process of self-learning turned into something absolutely incorrect. Another example of incorrect learning is the competition that was in the United States of America. It was a beauty contest, and the competition was led by an autonomous technology. Autonomous technology basically evaluated in the first round of this beauty contest that all black women, all Asians, and all brunettes should not be part of the second round. And basically, on basis of this incorrect decision of the artificial intelligence, only blonde girls made it to the second round. Again, this is an example of an incorrect self-learning. And I give you my personal experience. This is the picture how I draw the whale. There is a program you can download through your app, through your app store or Google Store on your mobile phone, and it basically tells you what you should draw. And when you draw it, it tries to recognize the object, and if you draw it correctly, it tells you what it is. And it told me that I should draw a whale, and this is how I draw the whale. But the whale looks like this, and the program actually recognized the whale. The problem is what you see here. It's a dorsal fin. The real whale has no dorsal fin. So it's an example how the program can have bad self-learning, because the people that think that a whale has a dorsal fin, like I do, are most of them. And therefore, they taught the program that a whale has a dorsal fin. Therefore, again, this is the example of how the program can be used for incorrect self-learning. And this incorrect self-learning poses a great challenge to a liability. There are other challenges that are connected with artificial intelligence, IT contract, intellectual property rights, cybersecurity, but the liability is the biggest challenge we face. In some countries of the world, like in Japan, they have already found it out, and in Japan, they adopted a liability act in 1995, which has a robot definition, and that works with certain exemptions from the liability when using the robots. Nevertheless, in our countries, in Czech Republic, in Bulgaria, in Romania, we don't have any specific regulation that would relate to robotics, and that would help us to exclude the liability purely on basis of self-learning. Therefore, the European Union has started with the discussions, and in 2017 European Parliament adopted a resolution with the recommendations on the robotics to the European Union. And the liability issues are the most crucial ones. In 2018, there was another communication from the Commission to the European Parliament, in particular on liability for emerging digital technologies. And the questions are obvious. Who is liable when the autonomous car causes an accident? Is it a manufacturer? Is it a software developer? Is it a distributor? Or is it a user? And under current laws, since we don't have we have not introduced in our legal systems the system of autonomous decision making, self-learning. The question is crucial. So we have to follow either on local levels or on the level of European Union how this question will be solved. And we don't expect that the clear answer will be given by 2020. So we have to be ready for the issues that will arise out of it, because we see that in 2020 we will have certain level of autonomous driving already on in the streets, and the way out of it is mostly the insurance. And I was talking about the Japan, and also in Japan the whole system gave rise to new products on side of insurance companies, basically insuring the manufacturers or distributors for potential torts, for potential claims that they might have from their customers. Of course, in some countries there is even a broader discussion like in the United Kingdom, where they adopted in 2016 the status of electronic person, and where they focus also in terms of automotive systems on labor law. So they adopted a legislation that deals with a compensation for job loss when you lose the job because basically your job was transferred to a robot, to autonomous technology. But this would be a much broader discussion, and we in our countries still don't have anything like this. Second topic, which will be much quicker, are the chatbots. We see a big rise on conclusion of the agreements, not only in automotive industry, through chatbots. It can look like this. So basically you have the application and you discuss with the operator whether you can book a room, whether you can book a car, whether you can conclude an insurance agreement. Also, these chatbots include an artificial intelligence. This is the example of HSBC and their virtual assistant Amy. Amy basically learns on basis of the experience from the interaction with the customers. And the great thing is that by using chatbots, you can also use the data you have about your customers. So you can customize your communication to the customer. You know that it's 25 years old guy, so you will use a different language. You know that the guy is searching once a year insurance for the extreme sports. You offer him the insurance for extreme sports. So this is a great challenge for conclusion of the contract in online world. Of course, it can look also like this very easily on mobile phone. And we see also the rise of conclusion of the contracts by chatbots in banking and insurance business, as well in car rental business. The legal challenge about chatbots, the biggest legal challenge, is connected to use of data. It means with GDPR. Second great challenge relates to consumer protection laws, because the European Union consumer protection law requires that you deliver to your customer a certain package of information. And when we were advising the clients with the chatbot solutions, we always try to find a way how to easily and let's say from marketing and commercial perspective friendly way communicate these kind of informations that we understand that most of the customers do not read, but you need to communicate. And in the same way, we try the solution to keep the way of communication like you see. It means user-friendly, online, and with a nice personalized customer experience. Another topic which is quite actual in online world are the smart contracts. Smart contracts are basically agreements that are concluded in form of source code. So you don't have any written agreements. They are mostly connected through blockchain. So they are based, the conditions of the agreements are basically expressed in programming language. So you connect to certain database or to certain program, and you conclude the agreements by performing certain actions. Let's have an example. I will skip this slide to provide you with a specific example that has already been implemented, not in Europe as far as we know, but in United States of America. If we have a contract concluded between the leasing company and the user of the car, you can have in the car so-called backdoor or backlog. If this car is connected to the internet and the whole agreement is concluded through the blockchain. So basically, the blockchain also monitors the payments of the debtor to the leasing company or to the bank when we are talking about the credit. If the payments are made properly on time, nothing happens. But if there is a delay with the payments, there can be in blockchain, through blockchain, there can be the automated performance included in the contract. For example, there can be the activation of the backdoor. It means that the car would basically stay locked until the payments are made properly. For example, if you are in a delay with 2 installments, the car can automatically become locked on the car park, and only the leasing company or only the bank would be able to open the car. When the installments are paid in a correct way, then the car became open again. If the last installment is paid, then the backdoor is deactivated, and the user can, the customer can use the car freely. These contracts in a blockchain are identified by automatic execution. So basically, these contracts you cannot influence. You can influence them only in the beginning when programming the source code. That is the disadvantage of the smart contract. Nevertheless, we see a huge activity of the clients in concluding these contracts. For example, also in supply chain. It means in supply chain that you can, in smart contract, very easily follow the payments. For example, if you make a payment through the smart contract to your suppliers, and then the payments are subsequently distributed to other sub-suppliers, this can be done automatically, and the ultimate beneficiary of the service, it means the person who ultimately pay all the suppliers and sub-suppliers, has it granted that the payments get to the sub-suppliers. There is a huge demand on the market, for example, for these kind of smart contracts. The legal challenge of smart contract is pretty much similar to what I was talking about with chatbot, that there are certain non-operational clauses that you cannot implement into the contract, like a governing law, like certain representations and warranties, and certain information for the customers, because smart contracts are part of the source code, and these non-operational clauses cannot be executed through source code. So very often we with our clients conclude a framework agreement before we prepare for our clients the framework agreement that is used for the first time, and then the smart contracts are part of the relationship that falls under this framework agreement, where we insert all non-operational clauses. Consumer protection, GDPR, and other issues related to smart contracts. Last topic I would like to touch is the use, is the example how to use the data in automotive industry. And I would like to quickly guide you through the PHYD example. It's a new insurance model that has been introduced many years ago, but now becomes very interesting because of the data analytics. The new insurance model is based on the logic that we would like to provide certain benefit to those drivers that follow the rules and drive properly, and it means that at the end of the day they avoid road crashes. The whole insurance model is pretty much based on the telematics that provides us certain data, certain history on the roads. We monitor, we evaluate, and on basis of this calculate the insurance premiums. How it works in practice: you can have several forms of technology installed in the car. It can be either a dongle, that is basically a device installed in the vehicle. It can be a black box, that is usually professionally installed black box on permanently level in the vehicle, but it's not part of the vehicle. It's something extra you install in the vehicle. Another thing is that you can use the smartphone. There are already some mobile telecommunication technologies that are based on telematics, and you can use it as well. Of course, smartphones is the cheapest way how to use it. These technologies collect the data of the driving, so it means it collects whether you exceed the speed limits, it collects the data whether you make enough breaks during the long journeys. It is very useful for collection of data in a vehicle fleet. It takes this data, transfer that to an infrastructure company that does the analytics. Infrastructure company can be either a seller of the car or any other firm, and this infrastructure company does the analytics and provide it to the insurance companies, and the insurance companies provide the invoice for insurance premiums to the customer. When the insurance companies have the information about better driving skills, not skills, better driving techniques, obeying the rules about the customer, they can decrease the insurance premiums to be paid to the customers by the customers. The infrastructure companies also provide the information to the customer. The legal challenges here is that first you must have a proper agreement with the customer, and then, since we are talking about the data that are personal, there must be proper agreements between data and infrastructure company, between infrastructure company and the insurance company, and these must mostly follow the GDPR regulation that relates to personal data. Currently, we have also advised a company that was using this kind of data through the telematics system in order to monitor the spare parts with the car and their usage. So basically, the company we were advising was using a software to analyze whether the tires for the big fleets are in a good condition or not. And this company also provided this information to insurance company, and insurance company decreased for a small portion the insurance premium for the fleets that properly visit the service for the inspection of the tires. The whole system in this particular case related only to big trucks, to big truck fleets. We see that the data analytics that can be used through telematics provided to infrastructure companies is one of the biggest topic, one of the biggest challenge for the automotive industry, and we see a huge activity and expect very interesting projects in relation to usage of data. This is one of the these are one of the reasons why using it, optimizing the fleet, route control, and most importantly, cost control. Ladies and gentlemen, I would like to thank you on behalf of Kinstala for participating in this seminar. Not only to this, let's say, hype information technology part. I hope you got some flavor what is going on and what will be the future activities in terms of technology and law in automotive system. I also would like to thank you for participating to previous parts that related to internationalization and also that related to certain employees matters. And in case you have any follow-up questions, feel free to raise them either to the email of my colleague Carmen or to my email. And once again, thank you very much on behalf of Kinstala International Law Firm.